reflecting the rise in climate change, globalization, populations, and wealth. The total volume of water on Earth is about 1 million cubic kilometers. Of all the fresh water on Earth, only about 0.3% is in rivers and lakes. These are the water sources we are most familiar with, and where most of the water we use in our everyday lives is found. Our climate models suggest that we will see seasonal shifts in precipitation patterns. If we have much less rainfall in summer, and the glaciers are no longer there to feed watersheds, many rivers may ultimately run dry for parts of summer and autumn. As a specialist in international law, my job is to ensure that water management has greater legal protection and adequate support in order to safeguard a vital resource that is unique in its multiple usage. The inertia of the climate system is such that we will not be able to reverse current trends overnight, so it is necessary to think about how to adapt to the impacts of a changing climate. The idea, beyond conducting research on the physical aspects of glaciers in the Alps and elsewhere, is to consider how to improve water governance and policies aimed at alleviating the problems of changing water patterns related to glacier decline before these problems occur. The number of people living in water-stressed countries will increase from about 700 million today to more than 3 billion by 2025. Protecting biological diversity means also protecting its lifeblood. For example, protecting freshwater resources. Freshwater resources are home to an extraordinarily high level of biodiversity, providing a vital range of resources essential for sustaining human well-being. One-third of the world's population lacks sufficient access to safe drinking water and sanitation to meet their basic needs. In only 40 years, global water use has doubled. Water can be a weapon in armed conflict, but history has also shown it to be a mediator of peace. Thus, the Indus Treaty of 1960 enabled India and Pakistan to resolve their conflicts through its mechanism of preventing and resolving disputes. In the case of Senegal, the Senegal River Development Organization has become the ultimate forum for dialogue between Mauritania and Senegal during tensions between them. There have been 1,831 interactions over water, both conflictual and cooperative, in the last 50 years. Public participation is important in water governance at the local level because it may furnish critical inputs and enhance the legitimacy and, more importantly, the sustainability of decisions. More than 200 water treaties have been negotiated. Some of these treaties have remained in operation even during armed conflict. Since the end of the 1990s, floods have become the leading cause of damage in natural disasters. Between 1975 and 2008, the number of natural catastrophes has risen from 100 to 450 a year, and it is continually increasing. Between 1991 and 2000, 665,000 people died in 2,557 natural disasters, of which 90% were water-related events. 97% of victims were from developing countries.
So, good morning, everybody. Mr. Deputy, dear professors, dear colleague, Mr. Inger. I'm very pleased, on behalf of the government and Republic of Canton Geneva, to open this round table on human rights and environment with a specific focus on water issue. This workshop takes place in the context of the Geneva's Week in Washington, which has been organized by the Swiss Embassy together with the Geneva Chancellery. The aim of this week is to promote Geneva's assets and activities dealing with public and private matters. In that perspective, and to embody the very dynamic academic environment in Geneva, the government has invited the Geneva Academy of International Humanitarian Law and Human Rights Joint Center of the Graduate Institute and the University of Geneva to suggest a topic for a roundtable. This challenging task aims to offer an attractive subject for an audience with high expectations and demonstrate the specificity of Geneva's academic expertise. Numerous scholars around the world have already discussed human rights as well as environmental issues, major concerns of our modern world. But the emergence of cross-disciplinary issues has considerably changed the approach of the multilateral work in international organizations and NGOs with a similar impact on research and academic expertise. New research fields, as well as new ways of conducting policies, increasing demand of international organization for academic expertise, its impact on practices and decision-making process demonstrates scholars' key position in the international Geneva. In particular, Geneva's based United Nations Human Rights Councils, the multilateral work of Swiss government and expertise of Swiss universities offer an opportunity to develop new vision, a more systemic way of considering major issues in the world. By taking into account the presence of international organizations in our city, Geneva's government is supporting university and has set objectives helping them to be particularly active in offering their expertise and developing research in major international policy issues by exploring topics that bring together scholars, practitioners, and policymakers in order to bridge the gap between theory and practice in international relations and contribute to shape the new Swiss profile in the high relevant fields such as the project launched by the Swiss Network for International Studies. I would like personally to thank the organizers, the Woodrow Wilson Center and his director, and the panelists for making today's event possible, and hope that Geneva will remain the place where open discussions, intellectual debate will always be guaranteed and will contribute to enhance the understanding of important and complex issue in the international affairs. Mr. Director, thank you so much, and I give you the floor.
Thank you very much, Mr. Schott. I appreciate very much you opening this session. We appreciate very much you coming to Washington to make this possible, share your insights, and we have appreciate very much your leadership as State Councilor for the Canton of Geneva. Thank you very much for coming and opening a session. And on behalf of the Wilson Center, I'm very pleased to be chairing this session. My name is Jeff DeBelko. I have the good fortune of directing our Environmental Change and Security Program. Our Europe program really is the ones that truly should be thanked for bringing us together on the Wilson Center side. But with the Swiss Embassy and the Geneva Chancellery, we appreciate very much this partnership to facilitate a discussion on a very important topic and bring some folks from outside the Beltway. A big mission of the Wilson Center to get voices and perspectives from outside this echo chamber of Washington. And so we appreciate very much our guests coming here. And at the same time, hearing from leaders in Washington, as we will today as well. So a word about the Wilson Center. We are very fortunate to have Jane Harman, former Congresswoman Harman, as our President, Director, and CEO, and she would want me to welcome all of you to the center, which is the formal memorial to Woodrow Wilson, our 28th president, the only one to have a PhD. So Congress in 1968 saw fit to set up a living memorial to honor Wilson, a nonpartisan, non-advocacy forum to bring together his worlds of scholarship and policy and practice. And so that's what we're trying to do here every day, and what we will do today with the discussion that, as you can see, reflects folks from both of those worlds. I will introduce very briefly our panelists, I think, in the order that they will speak, and we'll have a chance for discussion at the very end. Also urge you to stay to the very end, because when we adjourn, we'll be able to do that and pick up a buffet lunch right outside and bring it back in and continue our conversation. We are also sharing this conversation both live and then in archive video form with a live webcast. Really all that means for us here in the room is when it comes to the Q&A, if you could wait to pose your question for one of my colleagues to bring you a microphone so those folks online can hear your question as well. So without further ado, to tackle the topic of environment and human rights, we have a distinguished panel. Daniel Baer, who's a Deputy Assistant Secretary of State for the Bureau of Democracy, Human Rights, and Labor, is going to kick off with quick words and then offer his reflections too at the end and in the discussion. We appreciate very much Daniel coming over. Obviously, the State Department is a lead on these issues, and so it is terrific that he and his colleagues are engaging on these important topics. It was terrific to welcome Daniel. I believe after Daniel, we'll have Professor Andrew Clapham, who is Professor of Public International Law at the Graduate Institute in Geneva, as well as the Director of the Geneva Academy of International Humanitarian Law and Human Rights. It's terrific always to put face to name when you've read these people. It's great to meet them and have them come, which is the same for me for the next speaker. Laurence Busson-Duchesneau is Professor and Director of Department of Public International Law and International Organization in the Faculty of Law at the University of Geneva, and someone for me as a person who has spent a lot of time trying to understand water issues and development issues in a human rights context, someone that has contributed greatly to that literature. So it's wonderful to welcome her to this stage. And then finally, Ruth Greenspan-Bell, we're lucky to have here as a public policy scholar here at the Wilson Center for some months. Somebody who has been a friend of the center and a returnee, I think, was very active in our environmental change and security program in the mid-90s when we got started. Ruth, when she's not at the center, is at the World Resources Institute, a lawyer who has spent time in Daniel's institution at Department of State and a variety of contexts here in Washington on international environmental issues. So it's great to have her wrap us up. So I think without further ado, Daniel, we'll turn the floor over to you. It's on. Go ahead.
It's on. Okay. Thanks very much, and it's really great to be back here at the Wilson Center and in such august company as well. I want to start with the way you're always supposed to start if you're from the State Department, which is with a number of disclaimers about not taking anything I say seriously and et cetera. I'm kind of multiply encumbered here because, first of all, I'm not a lawyer, and so therefore nothing I say should be taken as indicating any knowledge of the law or having any implications limitations on legal aspects of policy. But second of all, being in a policy position constrains me as a academic, which I was before I came into government. I have long been interested, but not an expert in questions about the environment and about ethics and human rights and where those various issues intersect from a theoretical standpoint. I don't. I would like to come back for this conversation. I'm jealous of Ruth once I'm out of government and be able to have a full and broad ethical conversation about these issues. But as the policy guy today, I'm rather more constrained. I think the other reason why this, I think those things are probably particular to me, but I think more generally, I think this conversation is hard to have from a policy standpoint, partly because the policy of even the most progressive governments is still very much in flux and under evolution in the way that they're thinking about this. And that's partly because of the academic conversation is also, I think, still developing. And one of the things that we might do in the course of the conversation today is identify some of the kind of key questions that are being debated right now, the answers to which will determine the future of policy questions in this space. Because I think there are some key questions that are still very much, and I hesitate to outline them myself, but there are some key questions that are still very much under debate, both in policy fora and in academic literature and discussions that will will have a strong bearing on the future directions of policy in this space. I would like to say just generally at the outset, and then one of the things about events like these is that if you want to make policy pronouncements as a government official, you have to clear it by 37 people. But amazingly, they let us respond to things without clearing anything. So I'm going to be in the response mode mostly today, which is my preferred mode. But at the outset, I just would like to say, speaking about that evolution of the policy stance, under the Obama administration, the United States government has very consciously, I think, made steps to modify our policy stance with regard to ESC rights. And in some sense, that's really modifying our message on that, because I think there's been for a long time an idea that the United States government is somehow against ESC rights, or that we see these grand chasms between ESC rights and civil and political rights, and I think those often get overstated. I think a lot of the ways that they get talked about, including historically by some members of the U.S. government, as if they are both independent and separable, and as if they are sometimes in tension, is not the way that we see them. I think we see them as linked, inexorably linked, and we see them as we understand that societies in which civil and political rights are not respected are unlikely to be able to deliver on ESC rights, and we understand that in societies where ESC rights are not delivered, stable civil and protection of civil and political rights is unlikely to be fulfilled as well. And because we recognize that practical reality, we see progress on both measures as important. And we can point to some of the kind of gradual, yes, but some of the real progress that we've made on ESC rights in this administration in terms of the resolution at the HRC, which we joined on safe drinking water, and also the speech that my boss, Assistant Secretary Mike Posner, gave outlining our orientation toward ESC rights at the American Society for International Law conference in April. So I think we're still very much under development and in positive directions in this space. So I look forward to today's conversation and to learning many new things from the other presenters. So thanks very much.
Terrific. Thank you very much, Daniel. That's a great kind of policy context to set for us then to have this academic discussion, and we'll turn the floor over to Andrew to get us started in that fashion.
Thank you very much. Well, I'd like to thank the Woodrow Wilson Center for having us on this panel and for co-organizing this event, and also to thank the Canton and Republic of Geneva for including me in the delegation. It's a great pleasure to work with the Canton, and also to be able to thank them for providing scholarships for our students at the Geneva Academy, which means that people from all over the world can come and study the law of armed conflict in Geneva. The Academy, just to situate what we do and where my perspective that I'm going to be speaking from, the Academy is created by the Graduate Institute and the Law Faculty of the University of Geneva. And we are engaged in the policy debates on humanitarian law and human rights, as well as teaching an LLM in international humanitarian law. This is a law degree, and as predicted, some of my remarks are going to focus on the legal dimension of these developments. But I wanted to set the tone and sort of situate the discussion a little by explaining what's been happening recently at the Human Rights Council in Geneva, the UN Human Rights Council. And in thinking how to present this, I turned up the first speech given by Switzerland to the United Nations Human Rights Commission when Switzerland became a new member of the United Nations in 2003. That's nearly 10 years ago. Although it was the same foreign minister, federal councillor and Minister of Foreign Affairs, Micheline Calmy-Ray, was speaking to the 59th session. And in the English version of what she's supposed to have said, it's not as good as the French version, but I'm going to read it in English. This is how the UN reported it. The advancement and universal respect of human rights and of fundamental freedoms were one of the main activities of the United Nations. The Swiss people, she said, were committed to the fight for human rights and had chosen the path of dialogue and mutual criticism to uphold the values of democracy and human rights. The vocation of the Commission was to remain a unique forum, a space for dialogue, where the exchange of views was encouraged, animated by the will to constantly reinforce norms and mechanisms for the protection of human rights. This is in 2003, she said, the Commission was today at a crossroads and its credibility was at stake. The people of the United Nations expected a clear and transparent dialogue, a flawless ambition, and the consistent use of elementary and common values, and it was vital to live up to this expectation. Well, for me, there were sort of three key points there. Switzerland questioned the credibility of the Commission. There was an emphasis on clear and transparent dialogue. And thirdly, there was expectations set that in moving on from the Commission and creating this new Human Rights Council, one could maybe resolve some of those problems. It was a phase of high hopes, but I think 9 years later, I think it's fair to report, I'm ready to be contradicted in the discussion, that the Council does have an enhanced credibility these days. And there is maybe Dan will correct me if I'm wrong, a conducive atmosphere for dialogue, and there is some of these expectations have been met. And how has the Council enhanced its credibility? Well, two things stand out for me. First of all, they've been increasingly selective, the members of the United Nations, in choosing who gets to sit on the Council. And so both Sri Lanka and Syria have had to abandon their candidacies to sit on the Council in the last 12 months. They've realized that they can no longer expect to be elected. And Libya, as you are perhaps well aware, has had its membership suspended this year as a result of the human rights situation there. Furthermore, the action of the Council on Libya led not only to the completion of a report by a distinguished commission of inquiry, which was sent to Libya and reported back on the human rights situation, but it also resulted in the referral of Libya to the International Criminal Court by the Security Council. Now, if you couple all of that action on Libya with two special sessions on Syria, as well as the new mandate for a special rapporteur on Iran, again, something which the State Department, I understand, is proud of that initiative, it does show that the Council can now claim some credibility to be monitoring and reacting to human rights violations around the world. Now, on the question of dialogue, the biggest achievement must be the completion of a universal periodic review. Now, under this system, every state in the world reviews every other state for its human rights record. And the process of doing that has reduced the allegations that the Commission is somehow biased or selective. Every state has now passed through this review, and the focus is quite broad. It covers everything, economic, social, and cultural rights, as well as civil and political rights. And at this point, I thought, well, I will have a look through the report of the United States and how they were reviewed and some of the recommendations to see whether the environment came up.
Be careful, because I wrote it.
Well, I was half aware of that. So I'm not going to criticize the writing of the report,
Good.
But I thought
the prose was excellent. The substance was
and the substance were exemplary. And to be fair, because maybe this won't come out in the discussion, the process of writing the US report is really quite remarkable, and maybe Dan will speak to it later, in that there were consultations held across the nation with a number of civil society groups and NGOs, as well as indigenous peoples, and that's really what I'm coming to. That one of the points in the review that came out and that was recommended was that, of course, the effects of climate change should be looked into and so on. But there was one particular recommendation that caught my attention from Bolivia, and this recommendation stated that the United States should implement concrete measures consistent with the Covenant on Civil and Political Rights to ensure the participation of indigenous peoples in the decisions affecting their natural environment, measures of subsistence, culture and spiritual practices. Now, this was, as I remember, a recommendation which was accepted by the United States. And I think it illustrates how a human rights forum where, yes, on the one hand, there's a discussion of crimes against humanity and excesses by security forces and so on, can also be a forum for introducing maybe procedural ideas which would, in the end, help people who are going to be affected by damage from the environment and environmental change. Now, these are not decisions taken in a court of law, and maybe they're not that legally interesting, but my point to you today really is that a dialogue such as this has changed the tone of the debate in Geneva. That Bolivia makes recommendations to the United States accepts that recommendation. Of course, the proof will be in the next round of questioning whether or not some of these recommendations, not only made to the United States but to other states, are taken up. But there's something going on which is very different from some of the stale debates which many of us have witnessed in the past at the old Commission of Human Rights. Now, of course, that example on the environment is rather vague. I'd like to now move to, and maybe Professor Boisson de Chazorn will go into some more detail about what the Council is planning for the coming years. But I wanted to now go into two aspects of human rights and the environment which relate more to my own research, and that is related to the obligations of companies. And indeed, again, I worked with Dan on the International Code of Conduct for Private Security Companies, where he was very instrumental in bringing that to fruition. And it's a very interesting area. The Council deals with it in one way, which I will bring to your attention. The Human Rights Council has appointed a special rapporteur on toxic waste. And that special rapporteur, among other things, wrote a report relating to dumping of toxic waste in the Ivory Coast, which in the end led to a settlement between the company and the Ivorian government, as well as settlements in other cases between the victims of that environmental damage and the company. Now, the human rights dimension there is quite complicated, but what I'm again suggesting is that you can have a human rights forum, such as the Human Rights Council, where environmental damage is discussed in a detailed specific case. And just to give you maybe a little more detail, the settlement in the end was $1,500 for each of the 31,000 claimants. And a parallel settlement between the company and the state of Côte d'Ivoire was $189 million. So it's more than symbolic UN sort of resolutions. I would suggest to you that the work of that special rapporteur did in the end bring some sort of form of relief in very concrete monetary terms to those victims. Now, in the remaining time, I wanted to talk about a set of cases before courts, which have been brought before the European Court of Human Rights. Obviously, this jurisprudence and this treaty doesn't necessarily affect the situation in the United States, but I would suggest that there are actually principles which would be applicable universally. And one dimension of these cases relates to individuals claiming that a locally polluted environment has violated their right to privacy. And the technique of repackaging a question of environmental damage as a question of the infringement of your private or family life has been used by a woman called Madame Lopez Ostra against the Spanish government, which had failed to close down a waste plant which was causing a serious health hazard to her. Now, in that case, the European Court of Human Rights in Strasbourg found that the Spanish government had violated Mrs. Lopez Ostra's human rights and again ordered the Spanish government to pay 4 million pesetas, which is, I calculated, about $34,000. different case, which makes a different point, is a case of Hatton, brought against the United Kingdom government for airport noise in Heathrow. The residents near Heathrow similarly brought a human rights case complaining that that noise was infringing their right to privacy, dubbed in the British papers as the right to sleep. But that was a sort of facetious point because they claimed that their inability to sleep was actually having a deleterious effect on their health. This time, the European Court of Human Rights felt that the government was not in violation of its human rights obligations. They felt that the government had done everything it could to explore alternatives, and that the competing interests of the economy and the rights of others, the rights of everybody in the United Kingdom economy to benefit from EasyJet coming in at 1 a.m. and depositing a group of tourists at Heathrow, meant that the residents' rights to privacy were, if you like, not disproportionately infringed by the needs of the economy. So I use that to sort of suggest that framing this as a human rights question doesn't mean that you necessarily always get an unreasonable result, that courts are capable of weighing competing interests. Now, these are not just, I would suggest to you, two isolated cases. It's an important development, and it's now been replicated with successful claims against Italy with regards to a fertilizer production plant and a failure by the government to provide the inhabitants with information. It's this same point that in human rights terms, it's often the failure of the government to provide information to the local population, which is the hook on which a human rights case is won. That case is called Guerra against Italy. Then there were emissions from a private gold mine in Turkey, and the failure again of the authorities to close it after the Supreme Administrative Court had ruled it dangerous. That's Taskin against Turkey, and a Fadeyeva against Russia concerned a former steel plant. And the applicant had been put on a waiting list to be moved to another house, which would be away from the area where there was dangerous waste. And her number on the waiting list was 6,820. And she stayed on that waiting list for 5 years. And again, the European Court of Human Rights found that Russia was in violation of its human rights obligations for failing to move her. Interestingly, they said she doesn't have the right to a free house, but she has the right to be moved to somewhere else by the government. So that's one set of cases where the individual claims basically environmental damage under the heading right to privacy, and the court has to weigh alternate interests against it. I'll finish with a second type of case, which is where a human rights claim is made, and the government says we have to infringe your human rights in order to protect the environment, which is something that human rights lawyers have been thinking about now, that the environment becomes actually a justification for infringing on human rights. Now, here the interaction is obviously different. This case I'm going to mention is called Chapman against the United Kingdom, and Mrs. Chapman and her fellow complainants were gypsies, and they complained that the failure of the authorities to let them live in their caravans on rural land that they had bought violated their right to a private and family life as a gypsy with a traditional lifestyle which involved travelling and living in mobile homes. And the court found here that the measures pursued by the government of Britain had a legitimate aim of protecting the environment, protecting what in England is called the green belt, and the rights of others to a healthy environment, and that allowing people to settle in this way in the green belt was not permissible and was a legitimate infringement on their human right to privacy and family life and a traditional ethnic lifestyle, if you like. So those were just some examples I wanted to give you as to what has been happening in the human rights jurisprudence in the European Court of Human Rights, and also how it works at the Human Rights Council. I imagine that Professor Boisson de Chazorn will now take us forward on the other things that the Human Rights Council is doing. But this relationship between, if I can put it like this, pollution and the right to privacy, I think is interesting. I think there are contemporary challenges such as greenhouse gases and climate change that are mentioned in the Council, although nothing very concrete has come yet. I can report to you that the government of Maldives has traditionally now an action on climate change, because for that government, as you can imagine, the idea that the whole territory will disappear creates a real human rights problem for the individuals living there, where their existence is threatened by environmental change. So in sum, I think the challenge facing the Human Rights Council is how to balance these competing rights and competing interests. And in many cases, the choices will not be made by courts. They will be made by legislatures or the political branch. But I think articulating these problems as human rights problems is helpful. It forces states to justify why they have to make certain infringements. And it illustrates that environment is not really just a debate or a controversy, but it's something which impacts on rights to privacy, health, and indeed the right to life in extreme cases. And I'll stop there. Thank you very much.
Terrific. Excellent presentation, Andrew. Thank you. You really got us into it with both the setting the context for the council and then giving us these excellent examples on the environmental focus. We'll turn the floor next to Laurence and look forward to a discussion, particularly, I know, of water issues.
Thank you. I would first like to thank the Swiss Embassy in Washington for organizing this meeting, the Woodrow Wilson, the Canton de Genève, and the University of Geneva, to which I belong. I've benefited from their support, and it's a pleasure to be working with the University of Geneva. So after Andrew's presentation, which has stressed the framework, which is the Human Rights Council, I've chosen to speak about the right to water and to look more particularly to a specific request or claim that has been that there should be an acknowledgement of a right to water. And I would like to remind you the specificities of water. Without water, there is no life. And water is also essential for the fulfillment of a number of human needs and ecological needs. So this is a very particular natural resource which deserves, I think, a specific treatment. And our colleague Paola Gaeta chose the topic of water for this conference because there have been recent claims at the General Assembly of the United Nations and at the Human Rights Council for pushing for the recognition of a right to water, between brackets, and I'll come back to the formulation. And so that means that the countries, I think, are claiming, both developing countries and developed countries, it's not, there is no divide between the developing countries and the developed countries as to the importance of water. And there is an agreement that there should be a human rights perspective for the management of water. Now, this having been said, the question is, what does it mean? What does it mean in reality? Is it only rhetorical, or does it have any practical significance? For discussing it, because I think that we're going to open the floor for the discussion as to the relevance of claiming that there is a right to water, I think it's important first to look at the expression, the formulation. And you can look at the resolution of the General Assembly adopted in July 2010. It speaks of a right to safe and clean drinking water and sanitation. So it's not the right to water, but it's the right to safe and clean drinking water and sanitation. The same at the Human Rights Council. So there is an agreement between all countries that there is a specific formulation of the claim with respect to a human rights perspective in the field of environmental protection. Now, what is also interesting is that the Human Rights Council has appointed a special rapporteur on the issue, on the right to safe and clean drinking water. It is Mrs. Catarina de Albuquerque, who's from Portugal. And she's now claiming that beside a right to safe and clean drinking water, there should be a right to sanitation. And I think that is also something which is important for us, is that it is worth noting that a very large number of the world population still lack access to sanitation facilities. Okay? So you have the access dimension, but you also have the sanitation dimension, which is important. Now, where it seems to me that there is some disagreement is to the status, is in relation to the status of the right which is claimed. Some countries, and mostly the developing countries, and mostly Bolivia and others, are claiming that we should be speaking of a self-standing right. People are entitled to a right to a safe and clean drinking water and sanitation. Other countries, and mostly northern countries, are saying that, in fact, the claim for a right to safe drinking is deriving from existing human rights, such as the right to an adequate standard of living, or the right to life, or the right to human dignity. So there, the disagreement is still there, and it's going to be interesting to see what is going to happen. From my own viewpoint, I don't think it's that important to be claiming that there is a self-standing right or that this right is deriving from the existing right. And what Andrew has said earlier is that accepting that there is such a right deriving from existing right means that you have to reinterpret the existing rights in the sense, in the direction of water protection and water management. Now, what I think is important when people are claiming that there is a right to water, and that's going to be the practical aspect of this claiming of a right to water, is that we're going to be speaking in terms of accountability. What does it mean? I have a right to safe drinking water. That means that there are others who are going to be accountable for the providing of this water, this safe water. And there, what is interesting, and if you look at the reports of the special rapporteur, and she's going to be presenting her report tomorrow, so it's a timely meeting because we're discussing a report that is going to be discussed at the Human Rights Council tomorrow. What is interesting is that Catarina de Albuquerque is speaking of the responsibility of states. So states have huge responsibilities for ensuring safe access to safe drinking and safe water. But she's also speaking of the responsibilities of the non-state actors. And Andrew has mentioned the responsibilities of companies. We know that in the field of water management, you have public authorities which are providing water, but also private authorities. And what I think is going to be interesting is that through the framework that the special rapporteur has developed, we have now an understanding of some of the legal criteria which should be met when you have concession agreements and contracts which are negotiated. What are these criteria? Availability. Another criteria is quality, a certain type of quality of water. Another type of criteria is accessibility. And the other criteria is affordability. That means that there can be a cost to water, but it should be equitable. And all that now has to be taken into account. So looking at the report and looking at the writings around this acknowledgement of a right to safe drinking water, I was thinking that this is going to have a lot of repercussion in the field of investment law. Investors are no more going to be saying that this is a political issue, this is a human rights issue, that they don't have to take into account. They are also accountable. The states are accountable, but the non-state actors are also accountable for respecting certain basic human rights for providing safe and drinking water. Now, there is another dimension that the special rapporteur has stressed, which I think is also important. It's the fact that all components of a population, including the vulnerable groups, indigenous populations and minorities, should be treated in a non-discriminatory manner when asking for access to water. And this has practical consequences. And the special rapporteur has noted that, for example, among the Millennium Development Goals that were adopted by the General Assembly and should be fulfilled in not too long, 2015, there is one target that I'm going to read. It's the target to halve by 2015 the proportion of people without sustainable access to safe drinking water and basic sanitation. I'm not sure that we're going to be reaching this target, but at least there is a goal to do so. Now, what the special rapporteur has noted is that if you look at the Millennium Development Goals framework, what is interesting is that the Millennium Development Goal framework does not measure the discrimination aspect. There is nothing about discrimination. It's a quantitative approach. But what is interesting from a human rights perspective is that you have to take into account all the components of a population on a non-discriminatory manner. So this is opening the doors for minorities and indigenous populations and others to be claiming that they should be treated in an equitable manner from a water management perspective. Now, another value added of a human rights perspective, and I think that has been also tested into practice, is the fact that when we speak of water, we are also speaking in terms of decision-making processes. That means that water management is to be organized through an adequate decision-making process. And what does it mean? It means that all the concerned and potentially affected people should be informed about the process. They should have access to the information. They should be participating in the decision-making process. And they should have access to judicial remedies if their rights were not fulfilled. And this is what we call, and Andrew has mentioned that, the procedural dimension of human rights. It means that if you want to be speaking in terms of the protection of a right to water, you also have to satisfy some other rights which are important rights, such as the right to information or the right to participate to the decision-making process. And I'm stressing the importance of these rights because if you look at the case law of the Inter-American Commission of Human Rights, and there is an important case which is pending against Brazil with respect to the building of a dam, a huge dam. The Inter-American Commission has ordered provisionary measures because the indigenous populations have not been adequately consulted and they've not been participated, supposedly, in an adequate manner to the decision-making process. So there is a link with water and these rights. If you look at the case law of the inspection panel of the World Bank, you will see that the financing, the building of large infrastructure projects such as dams has also been the cause of a lot of requests before the inspection panel because the potentially affected people are saying, we were not there when you decided to finance this project and we should have been consulted. And so what I think is important with this element is that what we see is that when we speak in terms of water management, we have to include a dimension of sustainability, social sustainability. And what does it mean? It means that the people who are going to be the receivers or the people who are going to be affected should be part of the decision-making process. This is the social pillar of the notion of sustainable development. And the human rights bodies and the inspection panel have contributed a lot in the definition of such a dimension. Now, a few other words, and then we will have the discussion, is in relation to the formulation. I started by saying that there was an agreement among all countries that there is a right to safe, there could be a right to safe and clean drinking water and sanitation. And the point I'd like to make is that is this right as such enough linked to environmental protection? And with that, what I want to say is that we all know that water is a component of the environment, and that if you really want to have a right to safe drinking, you need to protect in an efficient manner the environment and the biodiversity. Without an adequate protection of the biodiversity and the environment, you're not going to have access to clean water, or you're not going to be able to satisfy all the needs of the population. And it's an easy example because we often refer to, but for example, the protection of wetlands is important. And we all know that most of the water of the city of New York is coming from wetlands in the state of New York. So without an adequate protection of the environment in the state of New York, there would not be the access to safe drinking water as we have in New York. The same for other cities. So what I wanted to say that for the time being, the way this right has been formulated it has been formulated through an anthropogenic formulation dimension. It's looking at the human needs. But we should also be looking at the environmental needs, the environmental dimension. And saying that, and that is a hope, that you might know that the Human Rights Council has adopted a new resolution, which is a resolution trying to link human rights to environment. For the time being, it's very difficult to understand what is going to be covered under the theme. People had been speaking of climate change and human rights. I'm not so sure that they went very far in the debate. So now it seems to me that there is a transformation of the debate and enlarging the concept and speaking of environmental and human rights. And I think for me that is important because speaking of environment and human rights, we're going to be able to bring an ecosystemic perspective in the context of human rights protection. Human dignity is linked to the protection, an adequate protection of the environment. The last word I would like to stress, and this is because I'm sitting next to two great experts, is that we've been speaking of this right to safe drinking water. And mostly we speak about this right in times of peace. But there is an issue of access to water in terms of armed conflict. And looking at the events going on in Libya, I thought that it was quite interesting to see that Gaddafi had shut off the water supply for most of the population of Tripoli, cutting a huge, what is called the Great Man-Made River, which is a huge engineering project. And so for that, there was a need for the qualification. And the question that I had was how water is protected under international humanitarian law. And it seems to me that it's still an orphan, and maybe we can come back to that. But what is interesting is that looking at the news, you have a United Nations human rights spokesperson who said that and I'm going to quote him, "Shutting off the water supply could possibly be classified as a crime against humanity." I think it's true, but it seems to me that it's going to be important to demonstrate how it can be qualified as a crime against humanity. So with these words, I thank you very much.
Thank you very much, Professor. Yes, sure, we should be applauding all along. Thank you very much for the detailed discussion of the water issues. Ruth, we'll turn the floor over to you now.
Great. Thank you very much. I just want to thank the organizers for including me in this very interesting discussion, and thank the previous two speakers for just very interesting and thoughtful expression and sort of framing of these issues. It's not hard to be persuaded that water is a fundamental right. I mean, you know, it's just taken as a given for many of us that when you turn on the tap in the morning, the water is going to be there. Very few of us in the Washington area think about where that water comes from. It starts off, our watershed starts off in West Virginia, and we're very dependent on states we may never visit for providing us the water we use every day when we cook, we shower, we drink, all the things, and unfortunately we fill our swimming pools and do all that stuff. So there's no reason to persuade me that this is not a human right. It should be a human right. The problem is how to make it concrete and how to implement this, this right. My own work over the last few years, although I'm actually here at the Wilson Center to think about domestic climate issues, I've worked extensively in thinking about the implementation of both international environmental agreements and also environmental laws and requirements in countries that have had great difficulty taking these articulations from paper to practice. If you look around the world, an awful lot of countries have pretty good-looking environmental laws on the books, but actual practice may often be as much as 180 degrees off of what the requirements are. And that is where that's the angle from which I come to this particular set of problems, which is how do you make this expression real? And I listened very carefully. I understand about the various courts that are trying to implement this. I understand about the organizations. But in the end, it comes down to thinking about what happens on the ground. And so I want to, building on something Laurence talked about, I want to give an example, a little bit of a devil's advocate example, but it's extremely real, about water in China. If you had come to some previous meetings over the years here at the Wilson Center that Jennifer Turner and Jeff DeBelko jointly sponsored about water issues in China, you will, or if you read the newspapers, you will know that China is suffering a tremendous water problem. They're actually accommodating this in a lot of different ways. Like, for example, they essentially import water by growing food elsewhere and bringing it to China. So food is being grown for, I mean, we all import food. I'm not saying we don't do that. But this is becoming a kind of a deliberate policy to work around the water constraints that China is facing. But China is also using its incredible resources, its engineering mentality, and its muscle to build these. I wish Jennifer were here because she has pictures of these pipelines that the Chinese are building to bring water from the more water-rich areas down near the Mekong, near the south, and take that water up to the north and to Beijing where it's lacking. And if you should do a little Googling and take a look at these astonishing pipelines that are being built that are costing billions of dollars, that are basically, there's been basically a peremptory decision not subject, as far as I can tell, to any outside review or even internal discussion that I'm aware of, to remove the water from where it is considered abundant to a place where it's considered scarce. And now you can say, you know, following on what we heard earlier, that this is increasing the availability of water. But it is increasing the availability of water for some people at the incredible expense of some other people. I'm also going to leave on Friday to go to Nepal, and there in part because we're thinking, I'm part of another organization, the Mountain Institute, that's thinking about the glaciers, the Himalayan glaciers and the other glaciers that we do work in Peru and in Nepal. Those glaciers in the Himalayas provide our major source of fresh water for, you know, any number of countries. 3 of those countries are nuclear armed: Pakistan, India, and China. And we are fairly fast. I mean, I know there were some disputes in the IPCC about what, you know, in the scientific literature about how fast we're going to get there. And when we're going to start really seeing the results of the melting glaciers. But if you really want to see something, just to remind you where we're going, Google Asia Society and Everest glaciers, and there's right there on the website, there's a picture of the glaciers in 1921 and the glaciers a year or 2 ago. And you don't need to be a scientist. I mean, I know there are going to be debates about how fast this is going to go and how long it'll take. You don't need to be a scientist to see that there has been major change there. Now, what I understand is that China is thinking very hard about how to divert those waters, those remaining waters, to its own use. The global security aspects of this are huge. How does, what I'd like to sort of, and maybe this is, I'm sorry to ask impossible questions because I know we're feeling our way through this problem, but how do we apply these principles that we've talked about to this incredibly real situation, which involves lives, genuine water, and investments that have already been made at a very high level to, you know, unilateral investments to make a decision that water should be the resource of China and not somebody else's resource. So I thank you again. I think this is going to be a really interesting discussion, and one we're going to be thinking about more and more in the coming years. It's not something we're going to be able to avoid, and you know, it could end up in violence. It could end up in negotiation. We don't know at this stage. It would be better the latter than the former.
Thank you very much, Ruth. I think with your China example now through the panel, we've referred to cases in just about every part of the world. So geographically, we're really covering the horizon in terms of trying to understand these environmental issues in the context of human rights. Thank you all very much. You've given us a lot to think about and to now discuss. So we'll throw the floor open to discussion. As I reminded you ahead of time, because we're webcasting, we'd like to get the microphone around to you. My colleagues will help do that. So we have one here in the middle and one here in the middle. If we could start, Andre, if you could come right down here. There's one right there, and then we'll get ready for another one there in the middle. And if you just, again, let us know who you are and try to keep it short. We'll perhaps collect 2 or 3 and then give the panel an opportunity to respond. So if we could start over here first.
Okay. My name is Julia Panuria Clonis. I'm a development consultant. And my question has to do about the role the Council can play in the foreign development assistance. There is a lot of projects and financed by multilateral entities and bilateral entities in projects that affect in the developing world, that affect both the environment and human rights. I wonder whether the Council plays any role in reviewing or advocating with these entities about how to formulate their programs and projects to take account of these issues. Thank you.
Terrific. Thank you for your question. Ma'am, in the middle, and then we'll move over to the gentleman in blue on the wall, please.
Yes, it was,
Yep, it's on. We can hear you.
this is Ann Kuntz with Relief International. It was touched on by you, Dr. Bell, but I'm wondering if the panel could respond to how the issues of food security are being integrated with the issues of human rights and water. I sit on a lot of groups that are looking at food security issues from the relief side to recovery, and frankly, the environmental side is a bit of an afterthought, so I'd like to hear from the panel on how that is being integrated.
It's a great question. Sir, did you have one as well? No, we can go over here. Okay. You do? Okay, we'll get it. We'll get it to you. Don't, there's plenty of time. We got lots of time. I got a list. But we'll get it over there.
Robert Schroeder with International Investor. Forgive us a more economic question, and I guess a legal one as well. We wondered if when you were trying to assess damage or reparations in any of these instances, in addition to the severity of the environmental impact, do you look at time, the number of years that any group may have suffered, and the opportunity cost as well, because it may have prevented some sort of economic gain or development in that area, those that would have avoided it because of the environmental degradation. And connected to that, I wonder if we could comment a little bit further about war zones. Is the UN or anyone that you know of doing any sort of assessment in Iraq, Afghanistan, Libya, about the overall damage, not just to the sewage and water treatment plants, but water delivery to the citizens, and of course the severe, we understand, environmental degradation that's going on as a result of the conflicts? Will the United States be held responsible? Will NATO be held responsible or accountable? I wonder if anyone would care to comment on that.
Terrific. Why don't we take those three, and then we'll start with the gentleman over here and the lady over here next. Who would like to kick us off from the panel in responding to those, any one of those three? We can divide and conquer here if you'd like.
I might take the first one on the development question and whether the Council has a role, because when there were discussions about what the Council should do before it was actually created, one of the ideas which I always found rather convincing and which hasn't yet been implemented was that during this Universal Periodic Review, I don't know, let's imagine that a state is up for review and another state sees an opportunity for a development project with that state. And then rather than making a sort of bland recommendation that it would be better if there was more development in that state, that they actually offer to carry out one of those projects. And so bilaterally, it would be a forum for arranging such projects. And so, I don't know, the state of Canada says that it's interested in helping the state of Bolivia on a question of a development project related to water, say, and that then it would be the forum for doing it. And then other states would sort of be witness to that and would sort of be interested in following up. Now, I think people were basically too excited at the novelty of being able to ask human rights questions of whichever state they wanted during the first round, and everybody got off their chest things that were bothering them about Iran or the United States or Cuba or whichever the country was. And that sort of spirit that it could be a place where development projects were worked out and articulated at a bilateral level. I mean, one of the examples which was always given, in my memory anyway, was that Canada could propose to Haiti a police training program rather than just saying the police in Haiti are not doing a very good job in human rights terms, and then there would be follow-up. So I offer you that for what it's worth, that during the second round of the Universal Periodic Review, it would be maybe worth suggesting to some states to take this up. Most of the states who ask questions, in my experience, have probably had the question suggested to them by somebody else. Diplomats in Geneva or capitals don't sort of wake up one morning and think what their question is going to be. There's a sort of intense period of lobbying by civil society and others. So I say this because I think it could actually work. Maybe I'll take the law of war questions because they're not going to go away. On Laurence's question, whether or not it's a crime against humanity to turn off the water supply, I suppose it is if you're intending to exterminate the civilian population. That's a pretty high threshold, and it would have to be widespread and systematic. Laurence kindly showed me the article. I mean, it was quite speculative, the UN's response, that if there really was an intention to deliberately exterminate the civilian population, then yes, indeed, it would be a war crime. Which brings me maybe to another point, because in the law of war, you talk about starvation of the civilian population. But as you all appreciate, if you don't have water, that's the equivalent of starvation. So I think a war crimes court would see that turning off the water was the same as a siege which was intended to starve the civilian population, and that therefore one could make the analogy. And I'll just finish on that point, that in human rights terms, we were asked, actually, one of the questions was food security. The right to food in the International Covenant on Economic, Social and Cultural Rights has generated a general comment on the right to water. So in UN human rights terms, you sort of generate the right to water from the right to food. And so, in my view, that is how the legal development would happen. Even if water is not explicitly mentioned in these treaties, it would be seen as equivalent to starvation or denial of the right to food. I'll stop there.
Thank you. Maybe I'll take a few points about the protection of environment in times of armed conflict to complement what Andrew said about sort of the criminal law dimension. What is, and it's also something which happened in Geneva after the first Gulf War between Iraq, when Iraq invaded Kuwait, there was a reaction of the Security Council of the United Nations and the establishment of the United Nations Compensation Commission for compensating a lot of the damages which had occurred from the invasion of Kuwait. And for the first time ever, the Security Council acknowledged that there were some environmental damages that should be compensated. And it's interesting to see that the current work of the United Nations Compensation Commission is dedicated to environmental protection. And what is interesting, and this, I think it's worth looking at the reports of the Compensation Commission, is that the assessment cost, the remediation cost, and the damage cost, and maybe the lost opportunities are covered by the report, so it's an interesting source. One has to say that there are not many sources from an international perspective, because obviously when there is a problem, very often the parties, the actors want to settle. It's much better to settle. It's confidential, it's not public, and so on, and so, and also there is very often a situation of inequilibrium of forces in terms of the negotiation. Now, I wanted to come back to a point that Ruth made about the examples that she gave, and for example, the situation in the Mekong region and the asymmetrical relation between China and the other riparian countries. And I think it's interesting for us, and it would be interesting to have the opinion of the others. When we speak in terms of human rights, the classical approach is to look at what the state is doing with respect to the individuals placed under its jurisdiction. Now, very often what a state is going to do from an environmental perspective is going to have repercussions and consequences in other countries. And it's interesting, if I've looked carefully at the case law of the Inter-American Commission of Human Rights and the Inter-American Court of Human Rights, and it's very difficult to establish this extraterritorial outreach of human rights protection. Now, and this is for the Mekong situation, I would like to refer to work which is now carried up, and it seems to me that when we're looking at the situation of a watercourse which is shared by riparians, I think there are solidarity obligations among the riparians, and that means that one riparian would not be able to take the water of others. There would be a breach and infringement of the principle of fair and equitable sharing of water, and I think that the case could be made. But this is where, and I think that Ruth is right, to say that the human rights dimension is important, but it's not going to be the solution to all the problem of mismanagement of water. And the same can be said about climate change. It was interesting to look at the debates which happened at the Human Rights Council with respect to climate change. Yes, there is a big issue about climate change. Yes, there is a lot of human consequences. Well, who is responsible for what? We know that the northern countries are emitting or have emitted a lot of greenhouse gases. They have a so-called historical responsibility. But now the main emitters are no more going to be the northern countries. It's going to be China, India, and Brazil for obvious reasons, the growth of the population, development, and so on. And so who is responsible for what? And it's there. The debate at the Human Rights Council has shown that the human rights perspective is not an answer for that, and that they need to find another way of looking at the solidarity issue. So I'll stop with that.
Okay. Any other?
I
Please, Ruth,
I just
yeah.
don't, I hope we don't forget the food security issue. I'm not really sure what to say about it. It has, you know, I mean, it's inherent in the water issues, and I don't have anything unique or, you know, I can't set off fireworks trying to, you know, with any solutions, but I do just want to note the importance of raising that question.
I mean, from my perspective, I mean, I think quite practically we see them as a policy matter as very similar, and then the question becomes, does it help to frame it explicitly and to always be framing it explicitly in a human rights context? I mean, as a policy matter, there's an imperative. You know, this administration has made the Feed the Future program a flagship program. I mean, there's a commitment, et cetera, and there's a recognition that this is important not just to the well-being of people, but to the stability of states, et cetera, the well-being of immediate people who are hungry, but also the sustainability of states, et cetera. So as a policy matter, I think they're seen very much through similar lenses, and so they are integrated in that sense. And indeed, they are integrated in the sense that we think about environmental policy and its effects and the consequences, et cetera, in the same conversations as well. So I don't know from a whether integrating it theoretically under a human rights lens is critical to driving commitment to that policy area. I think more generally this kind of strikes at your question of how do you, when you start with an anthrocentric view, and then what are the links to environmental policy? And one of the kind of questions that's emerged in general, you know, you said, Andrew, that it's very helpful to frame things in a human rights context, environmental issues. And one of the examples you gave, you said, you know, this shows that framing it in a human rights context doesn't mean that you come up with unreasonable decisions. To me, the question is, does it mean you come up with better decisions? And also, not only do we need to think about those decisions, but also the consequences for human rights of framing. Of using human rights as a bigger basket, because each time we do that, there is a strain that's put on the concept itself, and so there's that question. There's the question of is this actually a question of framing environmental issues in a human rights context, or is it actually a process, at least from a policymaker standpoint, of recognizing intersections of various policy areas, which doesn't require you to frame something as a human rights issue, but you can recognize human rights consequences, et cetera, of various other adjacent issues. And the security, you know, there's another adjacent thing, which is the security one, and in terms of the example that was brought up about people fighting over resources, the possibility of fighting over resources, what are the consequences if we do accept, if we were to accept a mode of talking about this as framing everything within a human rights lens, then how does that bump up against a security lens and I'm not saying that's a reason not to, but there are various consequences to framing something or packaging something under a particular rubric. On the IHL question, the Rome Statute obviously, as you were alluding to, does say purposeful, you know, deprivation of the things necessary for life, inter alia, food, et cetera. But the inter alia I take to be very permissive to include water. And then the Lieber Code speaks of poisoning wells in particular. So in that sense, water is specifically mentioned there. So there are some. I understand you said that it's an orphan. It is not prominent, but there are some seeds there.
Terrific. Before we turn to the next round of questions, just perhaps two other comments. One on the transboundary water impacts of one state to the other. I would ask the legal folks whether you see anything positive in the 97 UN Convention on Navigable Waterways, which is signed but not ratified by enough states to come into force, but seems to have the norms of prior notification and no significant harm from upstream to downstream. seem to be codified in some of the river basin agreements and such. So kind of being adopted while not formally in force would be one possibility to build on some of those kind of cross-boundary obligations. And the other, for Robert, in terms of assessments, I would point you to the UN environment programs. In fact, their office is based in Geneva, as opposed to Nairobi. They're the disaster and conflict branch doing country-level assessments of environmental impacts that include both the damage done by the conflict themselves, but also some assessment of the role that the resources played in starting and or continuing and or changing the ebb and flow of the conflict itself, as a terrific resource that includes assessments of Afghanistan and Iraq at multiple times, and with specific to depleted uranium and such. And so some really interesting assessments, including ones that you might understand why they'd be welcomed by the U.S. in terms of, in the DU case particularly, finding the very localized impacts as opposed to widespread impacts in the Balkans particularly. Okay, gentlemen, right here, we'll start and then we'll come across.
This was already partly discussed, but I'm thinking there are cases where it's very tangible who's doing the environmental degradation and whose rights are being violated, and then there are more abstract, or it's harder to trace. And I guess things like pollution in one country and you have acid rain in another. But then I'm especially thinking climate change, which not only is it spatial, but it's in time, right? Because people could be polluting here and then 30 years later an island is drowning across the globe. So does the HR aspect, how can you apply it, or are they thinking about ways to apply it, and how far have they come?
Terrific. The time variable again, and if we could hand it over right there. Oh, we got another one.
Thanks, Rich Blassie, environmental journalist. I have a question. If we could have a little more exposition about the Brazil case with the dam, and how perhaps it builds on earlier cases of the inter-American human rights system, famous case, Alice Tigney, and also, is there a possibility that there could have a human rights victory, but the state, one way or another, ignoring the decisions?
If you could hand it just two to the left there.
Diane Seeger, Washington Post. What kind of impact, if any, was the flooding of the Three Gorges in China impacted? Because a lot of people were moved and they just flooded that whole area. And that must have had quite an impact.
I think estimates were 2 million people. Yep, ma'am. We had a couple over here. If you could pass it just across the table, we can just work up.
Henry Hadker, researcher at NARA. I haven't heard any discussion yet of, recent inventions and new techniques that are threatening water supplies. One of them is fracturing. And I wondered what you had to say about that. It's a massive undertaking. It's providing a great deal of new resources for energy. But on the other hand, it could be critical in water supply. There's only so much water available. Humanity population continues to increase. The situation in time could become desperate, of course, and new inventions like fracturing pose a great threat, according to many newsmakers.
Okay, and then ma'am, we'll take one more for this round to give you 5 questions. You can pick and choose from. It's on, go ahead.
Okay. I wanted to ask a question about the whole issue of agricultural land grabs, agricultural industrial scale investments, where you have traditionally a lot of issues around what was the customary tenure right. So you had a lot of groups that have been fighting the large-scale plantations coming in for either energy crops or food crops. But there's also a very strong water issue that's there. And so I guess the question is, how do you see the defense of those rights evolving over time? Do you see it staying more around the issue of customary rights, traditional people's rights to their livelihoods and whatever, or do you see rights to water, which are obviously something in competition to them, being something that could give them a much stronger case where these are coming very fast and furious?
And largely completely undocumented because they're between private entities or sovereign wealth funds. Would folks like to again, divide and conquer with a whole panoply of questions there?
Let me, because I think most of the questions are best answered, perhaps all of the questions are best answered by other people on the panel. Let me jump in on the Three Gorges question, because I think it speaks actually to a broader point that was made about the importance of the failing of the MDGs to talk about the procedural justice aspects of environmental management, et cetera, and the importance more generally. And I think we've heard it in different ways through things that have been said. So, yes, the Three Gorges Dam had a huge impact on a large number of people. More recently, the protests that happened because of pollution from a factory in China were another example of people kind of speaking out about not being able to speak out. And I think one of the things that we try to convey, not only to China but to a number of interlocutors, is in environmental issues as well as other social issues, the importance of maintaining the ability of people to participate, the transparency of the management of the process, et cetera, is critical to being able to not only to come up with the best solutions, but also to be able to sustain them over time. And the interest of the Chinese government in having a stable society as it develops is not well served by the absence of outlets for people to speak out and express their concerns about these projects, et cetera. So we see that broadly across the board with projects that have environmental impacts and projects that are meant to provide water, et cetera. And I think this is this is at a number of levels. It's not just within societies that there needs to be the protection, but you spoke of this kind of the riparian states being bound together. I mean, that's clicking it up a level in a sense of saying, we have a shared resource here. People need to be represented in this case by their governments, and sometimes they're poorly represented by their governments. But that's another place where there's a kind of procedural justice aspect that we perceive it in terms of in how we manage. And then at the highest level, I think there's this question about how do we tackle the challenge, the global challenges of climate change. And I think, coming together at Copenhagen again last year and this year Durban, there's a clear recognition on the part of of the majority of governments that no one government can solve this, that we need to come together, that this is going to be procedurally, it's going to be, again, there's a procedural kind of criterion for how we tackle the problem, not only how we kind of manage the subcomponents of it, but how we tackle it, and that it's going to mean that people are going to have to come together from a variety of states at a global level. There's no one state that can provide the answers or provide all the solutions, and that we're going to have to meet out commitments that we each undertake to uphold, and that there are going to be a series of practical challenges. This kind of goes to your question of no matter how you speak of these things, how do you make it real? And those are the things that we still struggle with so much on all of those levels. So I mean, I think your question kind of was presents a single case that speaks to the broader procedural issues that have been raised.
Maybe I could take some of the questions. The first one in relation to the case pending before the Inter-American Commission of Human Rights. Obviously, the person who asked a question knows more about. But it's, I think that the case, I'm not a specialist of this case, but the case law of the Inter-American Commission is quite interesting, and in the Inter-American Court of Human Rights, because and this is because in Latin America and Central America you have a lot of indigenous populations, and these two judicial organs have developed procedural principles with respect to the involvement of indigenous populations in the decision-making process. And there have been some problem in Brazil with respect to that, but the Brazilian government is claiming that everything was done accordingly to the principles. I think what is also important to note is that, and this is a question too, it's the powers, the legal status of provisionary measures ordered by the Inter-American Commission of Human Rights. And I would say that from my own international perspective, I think they are mandatory, so they are imposing obligations on the states. Now, other questions in complement to what was said about the reports of the UNEP post-conflict unit, which is located in Geneva. I think one thing also that UNEP has done issued quite recently, which is interesting. It's the report in respect to the environmental damages in Nigeria, with respect to to huge environmental degradation in the Niger Delta, the Ogoniland. And it's going to be, I think, a reference document for assessing what are the costs and what are the damages and what are the costs of reparation. And there has been an admittance, I think, by the company Shell that remedial action should be taken with respect to this environmental damage, which occurred over 30 years, so it's a long time perspective. Another point in relation to the question which was posed about the 1997 convention, it's always tricky for lawyers because there is one universal agreement with respect to the management of international watercourses, but it has not yet entered into force. And I always say to the students, I don't think it's going to make much difference if it enters into force because most of the principles are principles of customary international law. But I think that what is interesting when you look at this convention, which was negotiated and adopted in 1997 under the aegis of the General Assembly of the United Nations, is that it's a purely interstate mechanism agreement, really. And there is not much about the human security dimension. And it seems to me that that is what is changing in terms of water management in the last years, that more and more there has been taken into account that if you want to have a sustainable management, you have to involve the populations. In one way or another, there is no perfect solution. And the special rapporteur, and that is also something interesting that comes from the report of the reports of the special rapporteur, there is not just one way of dealing with these issues. There are several ways, and we should take into account the cultural habits, the customs of the populations. But I think that if I go back to the 1997 convention, there is, even though human security is not really stressed, there is an admittance that when states are going to be sharing the water, which is in common, there is an equivalence of all the needs, irrigation, transportation, building of dams, and so on, but there is priority for human needs. And I think this is important, that there is an acknowledgement that human needs should be satisfied before all the other uses that you can make of a water course. And if you look at the draft articles on the international aquifers, it's even more stressed that the basic needs should be satisfied before the other uses which can be made of transboundary aquifers. So the other element that I could stress is that there was a case which was brought before the International Court of Justice which opposed Argentina to Uruguay, and that was about the building of industrial plants on the riverbanks of the Uruguay River. And there the International Court of Justice stressed that there was an obligation to consult the population. There was an obligation to conduct environmental impact assessments, and in the context of the conduct of an environmental impact assessment, the affected people should be consulted. So I think that this human rights dimension, this human security dimension is there, but as was said earlier, it's not an answer to all the problems of mismanagement of water.
Should I? Oh, go ahead, I'm sorry. No, I just wanted to make a small comment about fracking, which I don't know if everybody in the room knows what it is, but it's a process to release gas from, I think it's coal, it's from fracturing seams, and Jeff knows more about it than I do. I think there's a big struggle going on right now almost any production of energy requires water. I mean, wind is unusual, solar is unusual, although you have to wash solar panels to keep them clean enough to be collecting energy and making it available. Definitely nuclear uses a ton of water for cooling towers and things, and other forms of generating energy generally use water. And there's a lot of work going on right now trying to figure out whether the water use of fracking is unusual compared to these other water uses. So I don't have a personal opinion on it. I think what's happening right now is some states are, it's almost entirely being decided at a state level in the United States, and some states are saying go full blast, like Pennsylvania. And some states like Maryland are saying we really need to understand the problem better, understand the water and the pollution implications better before we let it go. And then in some places, it's even here a little bit, it's assuming some real geopolitical sort of aspects. I mean, I spent a lot of time in Poland, and in Poland they don't like to be dependent on Russia for their natural gas, and so they're really running very quickly into this fracking because they feel that that's going to be very beneficial for them. It's almost unpatriotic in some circles in Poland to question it because the alternative is Russia, not a reliable partner in the past to the Poles. So it's a very complicated discussion. I'm sure there are going to be separate sessions here and elsewhere around the city about these issues as time goes on.
I feel there's a sort of big question hanging in the air. Is human rights useful at all in this discussion? And I'd like to make the case again that perhaps it is. It doesn't solve all the problems. It's true that there are sort of multiple polluters, just to sort of simplify it. And so the issue is more complicated with sort of disparate effects across borders. However, I suppose the sort of theme of the discussion so far has been that in talking about human rights, you introduce these two rights, the right to information and the right to be consulted. And that actually takes you quite a long way forward. If you noticed, in all the cases that I raised, where an individual says, this environmental damage is hurting my human rights, the court comes back and says, it's true that you didn't have the right information or you weren't consulted. Therefore, your rights were violated. And if you put yourself in the sort of mind of a judge or in the seat of the judge for the moment, of course, it's much easier to find that there hasn't been a proper study done or somebody hasn't been consulted than to try and weigh up what is the environmental damage from any one act of pollution over years or impact on somebody's earning power and so on. And I would suggest to you is we're sort of stuck with those two important rights for the moment as the human rights weigh into this. On the question of fracking, I think one way into this is that where a company starts to engage in that practice, as you know, there are all sorts of demands now that you do some sort of human rights impact assessment before you get involved, either in a foreign country or in a new enterprise. And if you start to reformulate something called a right to water, that then brings you into the context of a human rights impact assessment. If the question of water is nothing to do with human rights, if a human rights impact assessment is only, are people going to be tortured, are they going to be disappeared, are their freedom of expression going to be impeded, then you don't make the connection. So talking about a right to water brings you within the context of a human rights impact assessment so that a fracking operation that's looking for export credit guarantees or some sort of outside investment would have to go through that prism. There was a question, what happens if a state fails to respect one of these human rights judgments? Of course, that does happen, but the context is both the cases that Laurence has been referring to and the ones that I introduced from the European Court of Human Rights is that you have a regional organization, the Council of Europe or the Organization of American States in those two examples, but this would also hold for the African Union cases. And there are some regarding oil pollution in the South Niger Delta against Nigeria. And in each case, the government feels obliged in the way that the sums I mentioned from the European Court are not so high. I mean, we're talking $20,000, $30,000, $40,000. In a way, it's better for Turkey or Russia or Spain or Britain to pay up than to be seen as a human rights violator in that context. So although it's not a 100% record, the political context is that states do statistically pay and settle. The last sort of question I had noted down here, is it worth talking about a right to water? Does it give the claimant a stronger case? I mean, I think if we're honest, once you reframe something as a human right, it does give it extra political traction. It does make it easier to articulate. And as Professor Boisson de Chazorn was explaining, the right to water could be seen as a set of composite other rights, right to information and et cetera, procedural guarantees. And therefore, by framing it like that, you then bring in a lot of other civil and political rights which could help the case. So I think it's more than just a rhetorical trick. I think it's a strategic device. There you go. I'll stop there.
Okay, terrific. We're ready for another round. Oh, yeah, please, Dan.
I very much agree with what you said in terms of, and it was one of the things I had written down, the cases that you read. The question is whether the wrong that was found was a wrong that was a right to a particular environment, et cetera, or or whether it was being 60,280 on the list for so long and that was not a fair process, et cetera. And so that raises the question of whether it's necessary to frame the environmental question as a human right rather than, well, there are two questions. One, do you need human rights at all in that conversation, or can you just claim it as a wrong? There are other wrongs against people besides violations of human rights. They're adjudicated in courts all the time, so do you really need human rights there? And second of all, do you need human rights explicitly a environmental human, something that not the U.S. government, but people might call a environmental human right. And so that was one of the questions I had. I agree with you. I do think, I agree, whenever you invoke human rights, one of the nice things, it is a sign, a testament to the success of what is really a remarkable amount of global consensus over 60 years around human rights, that it does have purchase, that it does mean things, but it comes at a cost. I mean, when invoking human rights allows you to get a $30,000 payoff from a court, you're selling off human. One view of that is that you're selling off human rights on the cheap. I mean, that's not what it's intended to do. I mean, if it's something that we are sacredly committed to, in some sense, then do we really want people being able to use it to get a $30,000 judgment, or a $30,000 judgment rather than a $25,000 judgment? And so that was the point I was trying to make about being conscious of the cost to the concept of human rights more broadly. I think it's much easier to use the civil and political rights that you were talking about in terms of process and access to due process and consultation, et cetera, because those are well established. People understand that. I think the cost of invoking that is lower, given where we are.
Okay. Do you want to? Sure.
I think the point is that in the cases that I'm mentioning, the people had obviously claimed a wrong, whether it's in Italy or Spain or Russia, but the system didn't recognize that wrong for one reason or another. And therefore, you can go to the international level, but to go to the international level, you have to reframe all your arguments as a human rights case, because you can't go to an international court and just claim I was wronged. You need human rights because that's what we do at the international level. And therefore, it wasn't just a sort of trivial wrong of being on the waiting list for too long. It was the rather excruciating wrong of having your health deteriorating every day because you're in a very, very dangerous zone which is unfit for human habitation. That was the problem. So it's more than just sort of repackaging to get the cash, if I can put it like that. It's repackaging to get the international attention. That's part of the human rights discussion. That's why it gets reframed, because you've got to go outside of your national legal order. Maybe, that the situation wouldn't arise in the United States, but in these cases they had to go outside the national legal order to get justice at the international level.
And it seems to me that we shouldn't attempt to solve problems with domestic law by innovating human rights. I mean, I don't think that innovating, that might speak to a problem with domestic law rather than that what we want to rely on is that you can repackage as a human rights issue if you want. I mean, I think that the question of whether people who have bought houses, I mean, most of the people who live around Heathrow have lived around the houses. Heathrow's been there for a while. Whether people have bought houses around Heathrow are now having their human rights violated. The neighborhoods around Heathrow are largely South Asian immigrants or second generation, et cetera. Whether that's the human rights wrong that we should be concerned about for those communities, or whether the ongoing discrimination in employment, et cetera, is, I think you end up weighing which of these rights do we want, which of these cases is really a violation of human rights that we ought to be focused on. And I think if there are problems with domestic legal systems in adjudicating wrongs, those domestic legal systems, we should focus on fixing them rather than counting on a way of working around them by invoking human rights, unless it is right to call it a human right, but it shouldn't be purely strategic.
Mm-hmm. Terrific, very good discussion. The gentleman in the middle, and then we'll come down, lady in the front.
Thank you. My name is Christopher Krause. I'm from the National Environmental Education Foundation. Edward Abbey would have described cities like Phoenix and Las Vegas as cities being in places where cities have no business being. And people are able to live there. Large populations are able to live there because we as a federal government decided that they indeed did have a right to be there, and so we built infrastructure and dams that allow people to live there and have golf courses and lawns that they water every day, et cetera. And as a result, the Colorado River doesn't always reach the Gulf of Baja. So I wanted to get your take on sort of a spatial component of this potential right to water. I mean, aren't there populations that are living in places or populations because they live in certain places that have no reasonable expectation to a right to water? And I think that this could touch on and maybe introduce a lot of other variables, particularly those related to climate change, where you may have populations that may have to move. And so, who is responsible for their relocation? We can talk about, attribution. It's the developed world that's created these CO2 emissions and changed weather patterns that are requiring me to move. But if I can just get your take on sort of the spatial dimension, where do you draw the line in terms of who has a right to water and who doesn't have a right to water? And there's also, of course, the intersection between that and environmental rights and the rights of nature and so forth.
Terrific. Very good question. We have one down here in the middle. If we can use the microphone. Thank you.
Mary Jane Deeb, Library of Congress. Actually, my question is related to the previous one. By framing a question in terms of human rights, don't we fall into the trap, and I'm playing the devil's advocate here, of having to choose whose human rights? In other words, exactly in terms of the many examples that you all gave, for example, building a dam and then dislodging 2 million people in order to provide water or energy or jobs to 20 million people. Legally, do we then decide human rights in terms of numbers, that it's okay to move 2 million people away in order to provide food and water to 20 million people? And it's a purely, I'm almost saying an academic question, but it does affect how decisions are made. And so that's my question.
Terrific. I think there's one over here in the middle. We can just pass it right across, or two of them. Great.
Thank you. Martina Gasser for the Embassy of Switzerland. I just want to broaden the question of the gentleman over there concerning the people who have to leave their wherever they live because of climate change. This is more of a refugee issue, and I hope it's not too broad for this discussion. But how do you think we should tackle this problem? Because this might be one of the major challenges following the climate change. How should that be tackled? Should that be in refugee law, or should that be more considered to be a human rights issue, for example, with a right to an intact climate or an intact nature or something like that? Thank you.
Okay, if you could pass it down to the lady to your left.
My question draws on some of the earlier comments, acknowledging the fact that there has been just a bit of progress regarding actually granting legal rights to the environment itself. And I just wondered if you had any further comments around that. So in contrast with some of our general discussions around human rights, but for instance, looking at Ecuador's newer constitution and kind of as a way to extend beyond the past legal arguments or approaches.
Okay. And Abby, could you just introduce yourself as well?
Oh, yes. I'm Abby Radis, and I'm a graduate of McGill Law School.
Okay, shall we take those 3 or 4 then?
I'll take the easy one and leave the difficult ones. They're all difficult questions, but this question as to if you're building a dam and 20 million people are going to benefit and some people are going to lose out, how does human rights help? I think you've identified exactly the limits of where human rights is helpful. You can't resolve that with a human rights discussion. It has to be resolved through democratic decision-making. However, having said that, democratic decision-making then implies that people will have a proper period of consultation, that studies will be done, and that the people who are being relocated do have a right to be relocated into adequate housing, not just bulldozed off their property for the benefit of the majority. So I think the human rights discussion changes how you see the construction of the dam and how you see the relocation. But it's not a magic wand which will help you decide who gets to benefit. I think that has to be done through a political process. And I'll stop there and leave the other questions for my colleagues.
I also think that those are important questions. I don't think that we yet have an answer. I often think, teaching environmental protection, that we're all living in societies where there are balance of interests which have to be made. And this, I think, is something which is also concerning human rights and the status of human rights in the international legal order. You have peremptory norms, that's for sure, that have to be respected in all circumstances. But most of the other rights, they can be restricted would the general interest be there. And Andrew Clapham has given examples of such legitimate restrictions before the European Court of Human Rights. And if you look at the many cases which have been brought before tribunals and courts and so on, it's quite interesting that economic development is often as important as the respect for human rights. And this is a choice of ours in our society. So I fully agree with Andrew that we need safeguards. We need safeguards, and the legitimate safeguards that we're going to have are the procedural rights, is that at least it should be a sound decision-making process, and full information should be given, and so on. Now, I think that the issue of dams is, we can't resolve it, and we can't resolve it from a human rights perspective. What I think is also interesting is that if you look at the climate change debate, we should no more be using fossil fuel energy. So which kind of energy are we going to be using? And this is a claim which is made by a lot of countries, China, Brazil, and others. If we want to satisfy the human right to energy that maybe some are claiming, which kind of energy are you going to provide? And very often the building of big dams, large dams, is seen or said that it's the solution. Now, the other question about internally displaced people because of climate change issues, because of infrastructural problems, I think that all countries have or should have legislation with respect to the relocation of the people. But with respect to climate change, it's a new issue. And if you look, for example, looking in Geneva at the work of international organizations, they are all looking at the issue of climate change and wondering how they can resolve it. And the High Commissioner for Human Rights doesn't yet have an answer for that. The International Organization for Migration is also looking at the issue. What I think is interesting from a climate change perspective is that we know and we have accepted, we all have accepted that a lot of people will have to move from their countries because some of the countries are going to be inundated and some of the Pacific Islands countries will disappear. We all know that. And also because there are environmental consequences that people are not going to be able to face. And that means that there is no right to return for these people. They will have to move, but they will not be able to go back to where they come from. And I think this is an interesting ethical dimension that we have not yet addressed. And this, I think, is going to be an important one, is that we have a collective responsibility to face, but we don't know yet what are the legal dimensions. And for the time being, we see countries which are choosing their people, saying we want these people because they are trained, so we're going to have them as migrants, legitimate migrants. I'm not giving any names of countries, but you have heard of that. We have other countries where we live, where we're building walls so that we're sure that nobody is going to come and so on. But with respect to climate change, people will have to move, and very often, and that's something that was said by the UNEP post-conflict unit, the conflict in Darfur was caused also by environmental problems and climate change issues. So there is a collective responsibility. But what is the answer from a human rights perspective? This is the question. There is another issue I wanted to come back to. There were previous questions with respect to the land leasing agreements and contracts which are negotiated. We all know of companies and countries leasing lands in other countries to be sure that they're going to have foodstuff and they're going to be produced, and then they will import this food for their population. There are now more and more articles and studies about the water dimension of these land leasing agreements. And there was an article that I read recently in the Herald Tribune which showed that the land leasing agreements negotiated with Sudan are going to have repercussions for the access to water for the riparian populations in the Nile. Okay? But this is not taken into account. And the claim which was made is that this land leasing agreement should also be looked at from the human rights perspective and from the equitable and fair the equitable sharing of the waters of the Nile. If you produce more food In Sudan, you're going to be using more of the water of the Nile, so some other populations are going to be deprived of this water. And what should be the consequences of that?
I agree very much with the challenges that have been laid out in terms of trying to solve these problems through to fit everything within a human rights lens. And I think it does speak to the, I mean, there's this question, and the question is not whether human rights are interesting or relevant to this conversation, but whether looking at it through a human rights lens helps us solve the problems we've identified and gives us guidance. And one of the things that, you talked about, about the process, and nobody's called us out yet on the kind of circularity of process and substantive, procedural and substantive justice, in the sense that the question about the 2 million versus the 20 million should be solved through a democratic process. Okay, but if I'm part of that process, can I use human rights as the guide for my input into that process? And I mean, I think at the very macro level, sure. I mean, the genesis of human rights is a commitment to human dignity, to valuing people equally, et cetera. And so the moral truths that underpin human rights, yes. The question is whether what legally human rights are, whether that gives sufficient guidance. And I guess I would submit, and this is me speaking as Dan, not necessarily as the U.S. government, but that in a situation, in terms of the substantive moral guidance that you need to participate in a democratic process like that, what we're actually looking for is more of a kind of Rawlsian original position. We're asking people both because of the trans-border issues, et cetera. I mean, it's not so much about the obligations of states that would give us guidance for that process. It's more saying, not knowing who I am, what would the judgment what judgment, and being committed to human dignity and the equality of persons, what judgment would I make about a fair way of weighing these two possible outcomes? And that's the substantive guide. And I think it's a more reliable substantive guide for solving the tough questions about who deserves what, and what you do after you move people. Those are practical questions, and I think going through that exercise is probably a more useful way, at least it would be for me personally, in judging what input I should give into that process and feeling confident in the kind of moral strength of that input.
Okay. Ruth, any final remarks? Okay. Well, I really think that on a highly complex and diverse topic, we have pushed the discussion forward in no uncertain terms with today's session. Of course, we've raised a lot of and gotten to some of the still vexing and challenging small questions and big ones, fundamental ones. But it does seem that institutions that haven't historically played as large a role or as constructive a role on these are increasingly doing so, with particularly, as Andrew laid out, some of these examples where we're seeing the human rights and environmental issues coming together and making that transition Ruth called for from paper to reality, so to speak, something that, as we all know, is not always the case, but is encouraging, and our focus on water allowed us, I think, to connect to some of these other issues that we're quite interested in terms of how the climate impacts will play out, often in that realm, certainly the connections to food as we establish. So a very productive discussion that I hope you will tell colleagues outside the room about and direct them to certainly the Wilson Center website, and I'm sure others that allow you to point them to the archive video of this. I hope that we're able to embed the video that was showing as you came in on that as well, so people can access those resources. And so we look forward to you sharing the insights from today's discussion as you go forward. Many thanks again to the Embassy of Switzerland and the Geneva Chancery and our collaborators and supporters in making this possible. And before we all thank our panelists for an excellent discussion, just a reminder to continue the conversation over a buffet lunch that's available just outside the room. So please now join me in thanking our colleagues.
It's tough. I don't know.
Can't wait to be an academic again.